Hi everyone, this is Paras. I'm giving the general overview to the new topic as well as an analysis of what the topicality debate will probably look like and places that we want to prep team. So, new topic. Plea bargaining ought to be abolished in the United States criminal justice system. We haven't had a crime-related topic since I was actually a senior. Actually, that's not true. 2013 was rehab versus retribution, but it was also my senior year. I think crime-based topics are awesome if you like small-scale util debate or if you like the K debate. There are certainly lots of fill positions as well, but it is definitely more concentrated towards the policy side. So we will talk a little bit about what is plea bargaining and the broader aspects of the resolution, and then I'll talk about topicality. I'm also happy to give insights on the util debate as well as the K debate, though there are also topic analyses that are going to go up on that. Just as a reminder for best practice, the thing I would like you to do after you've watched this TA is send me a message on Slack telling me 2 or 3 things that you've learned from this and 2 or 3 questions you have, and we'll get back to you and we can talk about sort of the areas that you're confused. So, what is plea bargaining? Please click on that link while watching this topic analysis. I'm sure that your screen doesn't show this diagram very well. This diagram is fantastic. I think a lot of people on crime debates don't have a good understanding of what the criminal justice system entails and how events process through the CJS. You have to have this background knowledge if you're going to succeed at a high level, because otherwise you're just uninformed and it makes it very hard for you to have hardcore empirical methodological debates as well as to understand a lot of the nuances that your opponents will be talking about. So let's just go through the whole process really quickly. Let's say that in a different life, I am a murderer and I have committed a serious crime and I have killed someone. So presumably somebody would report that crime and then there would be an investigation. Now, if I get lucky, that investigation is not solved and I get off and life continues. Usually that's not the case. Usually I'm arrested. Now, if I'm arrested, I can either be released without prosecution, which is rare. That would mean that the police officers clearly realize that they got the wrong person, or I'll get booked. And in instances where plea bargaining is an issue, i.e., criminal cases, or in cases of high civil worth, so like money laundering and things like that, usually you're going to end up getting booked. So when you get booked, you will either then just get released without prosecution. So that would be like the police officers once again realize they made a massive mistake. They shouldn't have booked you. At this point, the police officers have already opened themselves up to liability. You can and people have sued for emotional distress, etc., when they've been wrongfully booked. But most people who are booked end up being charged, and you have an initial appearance in court. So this is what we call when you have been charged with a crime. At this point in the process, Paras has been charged with the crime of committing murder. So I'll have my initial appearance. My initial appearance, almost always for criminal cases such as murder, will not just result in the charges being dropped or dismissed. Usually there will be an actual discussion by the judge about this, and there will be either some type of preliminary hearing or some type of consequence. So there are different types of crimes. Obviously, not all crime is created equal. There are petty offenses, there's misdemeanors, and then there's felonies. Those are usually the 3 ways that people describe crime. So, for example, a petty offense would be like if I went into a grocery store and stole like a Kit Kat bar, and the store owner got really mad at me and called the cops. That would be a petty offense where I'd probably plead guilty. There would be a sentencing. I would probably pay a fine, and I would be out of the system, right? And so in that scenario, it's almost unheard of that I end up in jail. However, if it's either a misdemeanor or a felony, there will be a preliminary hearing, and the preliminary hearing will be a little bit more in depth than the initial appearance. That there will actually be a prosecutor assigned to the case, and you will have had the opportunity at this point to either have lawyered up or to be given a lawyer by the state. And so then at this point, you will either be given bail or detention. Detention, usually you're given bail as long as they don't think you're just going to disappear off the face of the earth, and they think you have the ability to pay it or you're fiscally responsible enough, or some family member steps forth and is fiscally responsible enough. There are instances in which this does not happen and you're put in detention. Detention is just a fancy way of saying house arrest, but instead of being in your house, you're in court, or in jail rather. So you're just detained permanently, not permanently, but until you have an actual trial, or the trial is fully concluded. So yeah, if that was unclear at all, ask me a message on Slack, and I can point you to more resources. But the link I've sent you is very clear on this. So let's say now that we've been given bail. Bail is $50,000. Pars's family is really nice, decides to pay it. And for murder, obviously, it would be a felony. And so now on the chart, we would go to this side of the chart, the right-hand side with felonies. And this very clearly follows through the process of determining what happens next. There will be pretrial activities where the lawyers will negotiate amongst themselves or with each other. They will accumulate evidence. They will find witnesses. They will file motions to dismiss charges. They'll file injunctions, etc., etc. The pretrial activities actually can end up being the longest part of the case. The case can get dragged on for years at this part of the sequence of events, and especially because the lawyers have gotten very good at what people in the legal world called procedural motions. And so there's the substance or the content of the case, and then there's the sort of procedural part, like the way the evidence has been presented, whether it's followed all of past case law, etc., etc. And this is where court cases become really expensive. It takes forever, and this is also where plea bargaining happens. So the resolution we're going to debate is almost entirely based on these pretrial activities. And so that's really, really important to understand that this is the context in which we have arrived that you are debating. That, for lack of a better example, it would be Paras has been charged with a crime, he has been given bail, or he's been detained, he has posted it, and now we have pretrial activities. And the major pretrial activity we're debating is whether or not we should have plea bargaining, whether or not that should be an option or if that should be abolished. So, here are some key characteristics of plea bargaining. It's done out of court, so the judge is not sitting there and listening to every negotiation. It's done between the prosecutors and the defendants. And remember, the prosecutors are the people who are prosecuting the case, i.e. who are on the side of the state or the side of the victim. And then the defendants is the side that is defending themselves or saying that they did not commit the crime. So the perpetrators, essentially. And so it's done out of court. The judge is not going to be listening to every single fine detail. It's something that is done between lawyers. Either side can begin the negotiations. So it's not like the prosecutors have to begin it or the defendants have to begin it. Both sides can come forward to each other and begin it. There are several things you can negotiate. You can negotiate the facts of the case. You can negotiate the amount of counts that the defendant will plead guilty to, and you can negotiate the severity of the punishment. Now, there are different instances in which it's strategic to negotiate different parts, and we'll talk about that when we talk about speccing the type of plea bargaining on the T debate. But it's important to recognize that these are almost sort of like independent variables in a math equation where you can specify any of these, and any of these can be negotiated and are regularly negotiated. So only the judge, however, will be able to control the C point, which is punishment severity. So let's say I commit a crime, and then it turns out the prosecutor is like a really good family friend, and we negotiate, we come to a crooked agreement, and we recommend to the judge that, we think Paras is a really great guy. He should only be punished for 24 hours. The judge doesn't just have to accept the recommendation on punishment severity. So that's important to recognize, is that it is just a recommendation and that the judge controls sentencing and punishment. However, the judge does not have as much discretionary control over the A point and the B point. So if we agree that I'm only going to admit guilty to one of the 3 counts that I've been charged with, then the judge usually has to agree and abide by that agreement. So the only place where the judge can sort of veto or override the plea bargaining stuff is on punishment severity. Great. So that's sort of a broad overview of what plea bargaining is. Let's talk about why it's useful. There are 4 big reasons why it's useful. Defendants can avoid time and cost of defending themselves at trial, the risk of harsher punishment, and the publicity a trial would involve. Publicity also is really important for people who are famous or who have reputations they're trying to save. Basically, every time somebody Googles your name and you're in the middle of a criminal trial, the criminal trial is going to come up, and that's not great for your bottom line, be it your brand or the amount of money you're spending, etc., etc. And there's also the possibility that the prosecutors have some really sweet concrete evidence that you don't know of, and that will make it so that you will for sure be guilty. And so it sometimes is sort of like almost like a gambling proposition where you're trying to figure out what type of dirt do they have on me, how likely is it that I'm going to get in trouble, how much time and energy and money will I have to spend to clear my name, and how much consequences will exist with my public reputation, and is all of that worth it? Is it worth fighting to clear my name, or should I just accept this deal to plead guilty to a lesser charge and get a slap on the wrist and move on? So that's from the perspective of the defendant. From the perspective of the prosecution, it saves times and expense, right? So the prosecution, especially if it's the government, doesn't have the bandwidth, especially in terms of money and resources, to keep lengthy trials going. Lawyers change jobs all the time. The federal budget is not just infinite; it's highly elastic and variable. And so it's really important to understand that this is both sides are incentivized to make sure that the trial is only being conducted if there's a legitimate disagreement over the facts of the case, because otherwise, it just ends up being really expensive and lengthy, and one judge can only hear one case at a time while they're listening to that case. So they can process multiple cases at once, but keep in mind, right, like a judge can't listen to two cases simultaneously, just like a debate judge can't listen to two debate rounds simultaneously. So it really is one round at a time or one case at a time. And unlike a debate tournament where there's not really a huge consequence at the end, we're talking about people's lives here. And so this is really important. This is where the court clog disad becomes really relevant, because if the courts get clogged up, then people aren't getting justice served, et cetera, et cetera. And so this is sort of the human side of justice that I think sometimes debaters lose sight of, is that justice isn't just some, like, especially in the criminal justice system, punishment and adjudication of the facts of the case isn't just a purely objective matter. There's this really real resource question as well that we struggle with and that we constantly have to balance. And this is where you start seeing statistics like 94 to 95% of cases that currently are processed in the CJS are settled by plea bargaining. And CJS is criminal justice system. Sorry, that's an acronym you should get used to. So yeah, that's the second major sort of reason why plea bargaining is useful. The third one is that both sides are spared the uncertainty of going to trial. Going to trial means it's just a probability question, right? If you know 100% that you're going to be able to put this person in jail for a year, whereas you only have a 30% likelihood you'll be able to put him into jail for like 6 years, usually you're going to be like, well, at least we can get him in for a year and we get to like resolve this case much faster. Sort of the benefits outweigh the costs. And that's the approach people end up taking, both on the defendant side and the prosecution side. And the last one is really just a fancy way of saying court clog. The court system has saved the burden of conducting a trial on every crime charge. That's important because otherwise the criminal justice system would probably collapse, which would not be great. And we will talk about that in the util TAs. So let's talk about topicality. Enough of the general overview. If there are still things that do not make sense to you about what generally is the history of plea bargaining, let me know and I will clarify that. So there are 4 general areas of spec for T. You can spec locations, like do the AF only in Montana. You can spec the type of criminal case, i.e. abolish plea bargaining only for sexual assault cases or child pornography cases. You can specify the type of group of people who it's abolished for, so like abolish plea bargaining or only for wealthy people or only for white people or only for middle upper class Indian people. You can specify the types of plea bargaining. So if you remember, I was telling you that there are different things that can be bargained over, right? You don't just bargain over the punishment, you can also bargain over the facts, you can bargain over some of the stipulations that exist within plea bargaining. So for instance, like you can bargain over, it turns out that if you're an illegal immigrant and you are charged with a criminal case, you have lost your right to be on a sanctuary campus, and that's a stipulation of the process of plea bargaining, and so you can bargain over that, whether or not you have the right to continue having sanctuary campus status, because otherwise you would get deported underneath the Trump administration. So yeah, types of plea bargaining is the 4th general area of spec. Now, keep in mind, these are all independent permutations, right? So you could combine as many of these as you want. So you could say, like, only child porn cases in Montana for people who are in the 1%, and only the facts get checked in those cases, or we abolish fact-checking. Now, that AF would be super strategic because it would be so small, and there would be no way to answer it substantively, presumably. But downsides are it's probably pretty abusive, and there probably isn't a solvency advocate. But the way the circuit's going, who cares about any of those things? Like, it's probably likely for at rounds of TOC that we have several of these AFs that's just like really ridiculously specific. I do think that responding to the T shells that are like you can only specify 2 of 3, you can't specify 3 of 3, is going to be the hardest part of those debates. But we can talk about that some other time. So let's talk about plea bargaining. Plea bargaining as a concept is not very ambiguous, but some people could try to read AFs that abolish specific forms of plea bargaining or specific stipulations of plea bargaining. So, for example, the sanctuary campus stipulation would be a good example of that. Having a legal dictionary definition that defines what is plea bargaining is probably the most effective form of evidence here. This is where it's important to remember terms of art. This is a legal topic grounded in the United States domestic criminal justice system. And so it is best if we are citing legal scholars and legal authorities as opposed to dictionary definitions or random professors. So I would prefer if we're citing like lawyers, and ideally judges would be the best if we're citing like actual court cases. So I know there was a 1970 Supreme Court case about plea bargaining. I'm sure there's a definition in there. Someone should go pull that, and that can be our definition. But ultimately, the T standards can be things like contextual usage. Legal topic means legal terms. We have the best legal definition. Framers' intent. Obviously, the framers didn't intend for us to talk about like sanctuary campuses. If they did, they would have said that in the resolution, and they would have made it much more specific. Things like topic literature. The literature almost unanimously will be much wider than the way that these AFs manifest itself, which also means that there's a lot less clash on these AFs because there's just a lot less ground to begin with. I do think that this will be a popular form of spec, especially as the topic gets deeper and deeper. I can envision schools specking like just getting rid of specific types of plea bargaining as opposed to plea bargaining as a whole. And the reason why is because that means the court clog disad and a lot of the disads that the negative is likely to read end up becoming a lot weaker, especially at the level of the link, because you still allow for plea bargaining in the AF world. You just allow for like a limited version of it. Cool. So the next word I want to talk about is ought to be. I'm going to be very brief here because this is not going to be very popular, and the debaters it will be very popular with are shady tricks debaters that we will probably end up having theory or like K debates with anyways, so we don't need to worry about this too much. Some East Coast debaters might end up saying that ought to be is a value proposition and thus not a question of policy but rather value. I imagine this will be popular at smaller Northeast tournaments and at Florida tournaments, slashing against debaters who are trick/framework debaters. I think that the sort of like obvious logical flaw with this form of topicality is it assumes that the concept of normative value isn't grounded in policy, and presumably the whole point of the AF's normative framework is to challenge that assumption. So absent our framework being like massively theoretically justified as opposed to normatively justified, I don't see this being an issue. And at the point where our framework is theoretically justified, then we just have a T debate about like what type of debate is better debate, util debate or framework debate, and that is a debate that we can prep you guys on, but I don't envision this being very popular or high priority. So yeah, talk to me if you have any questions about this. I'm going to be brief about it because there are other things that are much more relevant and I think useful. Let's talk about T abolished. This is an important one. So, according to the Collins Dictionary of Law, abolish means to terminate the legal effect of some provision or doctrine. So in this case, the provision or doctrine would be plea bargaining. Now, is it a specific part of plea bargaining? I don't know. It depends on where you stand on spec, and AFs that spec specific things will say it will be just some provision, not the entire provision. The colloquial definition of abolish is very clear and straightforward, right? It means to completely get rid of. If I abolish candy from my diet, that doesn't mean I still eat Starburst on Sundays as a cheat meal. That would be ridiculous. It would be using the word abolished in an improper manner. Now, this is going to be a very popular T debate. It's the same spec debate you have on every single topic, right? Like, should the AF have to defend the whole res, or does it get to defend a subset of it? Does it need to get rid of plea bargaining as a whole in every instance that it is used in the criminal justice system, or can it choose specific instances in which it wants to get rid of it? And so usually I think that abolished is a pretty straightforward word in the English language, but the way the debate metagame has been trending towards plans, I think we will see debates about whether or not we are fully abolishing plea bargaining. One thing I want to recommend to you guys, there's a really clever iMeet here in the 1AR. The iMeet in the 1AR is we do completely get rid of the legal effect of this doctrine. We just get rid of it in a specific instance. And so they will say, I do abolish plea bargaining. I just abolish plea bargaining in situation X. X. And so really what that tells you is that maybe the right T shell to be reading is T plea bargaining, or T United States, which we'll talk about in a bit. Or T criminal justice system, as opposed to T abolished, because they could get away with this semantic sort of I mean that I do abolish plea bargaining in this instance. It is never used again. It is terminated. It is completely gotten rid of in the AF world, but it's just only in instance X. And so this really gets back to the heart of the Niebel T debate, right? Like, should the AF get to spec a subset? Cool. So that's the abolish debate. And the T debate here will look very similar to the T debate on every other topic. If the AF gets to choose which portions to abolish, it's literally nearly infinite permutations. You can choose any of the 50 states. You can choose any type of crime. You can choose any group of people. You can choose any aspect of plea bargaining. So that's like 50 permutations by like probably there are at least 15, 20 types of crime. So 15 times 20 times there's like probably dozens of categories of people. So if being generous, they'll say there's 10 categories of people, which is obviously an understatement. That's 15 times 20 times 10. We're already at 10,000 AFs, guys, assuming that the AF gets to spec without any limits, right? Now, obviously, the AF will place limits in the form of disclosure or solvency advocate or presence in the literature, blah, blah, blah. But point is that the limits claim here is the exact same. The semantics debate will be very similar, but instead of having semantics debates over operative terms and past resolutions, like on last year's JanFeb was like the key question was what is constitutionally protected speech. Instead of having that be the debate, it's now going to be about like what does it mean to abolish something? What does it mean for something to be plea bargaining? So yeah, plans good, bad, subsets good, bad is essentially the crux of the issue here. And all of our files here will be very helpful. I encourage you guys just to make sure you're very familiar with the front lines, you've timed them all, and to reach out if you have questions about that debate, because that's probably my favorite debate to teach. Cool. So let's talk about T United States. Some people will try to specify specific states/regions in the U.S. Some people will also try to specify specific actors, such as the Supreme Court or the federal government or specific states. Some people may even try to specify different countries. Obviously, shout out to Jack for specifying Mexico. Hopefully, none of y'all think that's a good idea on this topic, because I definitely think it's a terrible idea. But the first two are much more nuanced in terms of whether it's good or bad. California is in the U.S., so presumably specking California is okay if you think plans are okay. And I think there are really interesting reasons why we'd want to spec a specific state. Think about the court clog disad. If we choose a state where there's not a lot of court clog or where there's not a lot of crime, we auto no-link that disad. Think about if our AF is specific to like financial crimes, it would be maybe smart to do it only in Delaware or the District of Columbia or in New York, where most of those crimes are committed and charged and tried, right? And that reduces the scope of the AF. That reduces the link to the politics disads. It reduces the link to the court clog disads. It reduces the link to the international modeling / hedge disads, which people will talk about on the util TA. And so that's really, really important for you guys to understand is the strategic value of this. Now, obviously, the resolution doesn't specify an actor. It doesn't say who is going to abolish plea bargaining. It just says it's going to be abolished in a context, which is the criminal justice system. Plea bargaining doesn't really happen outside of the criminal justice system. And so the question is, does the AF have to specify an actor? A-spec is going to be popular on this topic. A lot of people will say you either have to specify in cross-examination or grant me links to a disad, but you can't say normal means or take no stance, and you have to tell me what normal means is if you say that's the route you're taking. So I will talk about this a little bit more later in the analysis, but that's a broader level overview to T United States. So next, let's talk about T criminal justice system. 3 parts to the criminal justice system. This is, again, basic knowledge that I really want you guys to make sure you understand crystal clearly. There's police / law enforcement, that's part 1. There's the courts, that's part 2. There's jails / prison / rehab, that's part 3. So in other words, there's catching the crime, there's processing the crime or adjudicating the crime, and then there's punishing the crime. So you got to catch them, you got to process it, and then you got to punish them, right? And that's the 3 parts of the CJS. So that is what they mean by we abolish plea bargaining in the criminal justice system. Now remember, on that diagram we were talking about at the beginning of this TA, the police / law enforcement part happens before the courts, and that has nothing to do with plea bargaining. So plea bargaining is entirely oriented around this second part, which is the courts. It has impacts in terms of the jails, i.e. in terms of like court clog and things like that, but it doesn't have any direct link into like action being taken by police officers or by prison guards and things like that. So Apps that defend actions taken by police or jails will be extra T. And some apps will do this because some apps will try to solve for the court clog problem or for the other problems that exist when you abolish plea bargaining by saying like, oh, well, we'll do this, but we'll also create like 100 extra federal judge positions, and we will fund it extra by the federal government, and we will increase the amount of police officers on the streets so that way there's less crimes that happen, or like people are more deterred from committing crimes. All of that stuff is extra T, and we will also talk about that, but it's important to understand that T criminal justice system is a T shell we need ready to go, especially one that defines plea bargaining as only related to plea bargaining or only related to the courts, and so it's not related to the law enforcement and to the rehab / punishment like prisons and jails, and that's really important because that means it clearly makes the AF extra topical, and it means that the AF's jurisdiction in terms of fiat is specifically only on the courts debate. So let's talk about ASPEC. Who implements the AF? What is normal means here? It's not clear. It could be the courts and it could be the federal government. If it's the federal government, obviously it'll get tested by the courts. And if it's the courts, then it would be shocking at this exact moment for it to happen because I don't think there is a case in the docket about plea bargaining. And it could also be the 50 states. This is part of where policy and util debaters, I think, really focus on being tricky. And so it's really important that you ask and cross-sex. And if you have disad links to politics or other things that are based on them specking, then you really need to know what they are defending, because if you forget to ask, it can lead to the 1AR shifting completely. And I've seen this happen over and over and over and over again in really big debates. So yeah, it's really important that you guys ask and that you are ready to force the AF to defend something or read a shell that says, look, you have to defend something. Now, one trick people will do here is they will say, I just defend normal means and I refuse to specify further. The follow-up question in cross-ex must be, that's fine, I respect your right to defend normal means, but you also have to tell me what normal means is. Like, tell me what the normal means of the AF is. Where is this evidence? Give it to me, right? And they can't just hide what normal means is until the 1AR. That's ridiculous. And I think the shell that's like, if you spec normal means, you have to explain what that is in cross-ex is super reasonable and very true. And so if that doesn't make sense, please, please, please message me. But implementing the AF is going to be a debate that is had repeatedly that you guys definitely should get comfortable. It'll affect the politics debate, it'll affect constitutional law disads, and it'll affect actor-specific NCs and disads. So remember to ask, remember to feel comfortable forcing to defend a potential actor, and we got to think about which actors we defend when we write our AFs. Cool. So the last part of this topic analysis is just quickly talking about the potential areas of the AF being extra topical. So the AF is going to want to propose solutions that, okay, taking one step back. The AF creates a massive problem for itself. When it gets rid of plea bargaining, there is a 20-time increase in the amount of cases that are processed in the criminal justice system. Right now, 95% of cases, I think, are resolved via plea bargaining. So the AF gets rid of a tool that is used 95% of the time, which means that if the courts see 10 cases a year, they all of a sudden are going to see 20 times as much as that. They're going to see 200 cases a year. And so that means that they need extra capacity to see those cases. Otherwise, the court system will quite literally collapse. And so obviously, if we abolish plea bargaining, something will happen and there will be some adjustment made both federally in terms of the law and legally in terms of courts. And so it's important to figure out what that adjustment will be, but you have to remember it's not within the AF's right of fiat to specify what that adjustment will be. That would be fiat abuse. That would certainly be extra T, and there will be AFs that go about doing that, and so we need to be ready to call them out on it and make sure that we're limiting AF fiat power to only the plea bargaining and not to other solutions. So not doing things like saying that they can increase the amount of federal judges that evaluate cases, or that they can institute another different tool, et cetera, et cetera. And so I think that really is important to remember. And really unique ways this can happen is like AFs can be like, well, we're going to phase out plea bargaining over 20 years, so we're going to just reduce it like 5% a year. And that I think would be extra topical. I think if you're going to abolish it, you got to abolish it probably right away. But that's a debate to be had that we can talk about the pros and cons of. But yeah, so just to take one quick step back, this is hopefully a pretty comprehensive introduction to topicality. Slack me with a couple of things that you learned that you didn't know walking into this TA, and a couple of questions you have. And any general questions you have as well, please post them, and I would be happy to give more clarity. So I'm wishing you guys the best of luck, and I'm excited to see how everyone does on this topic.